Hey guys, this is part 5 of the series on how to draft an employment agreement. Today we are going to talk about termination clauses in an employment agreement. It is very important to include a termination clause because if you don't, then the termination notice periods will be governed under Section 10 of the Employment Act. You can have a look at the notice periods over here. For employees who do not fall under the Employment Act, that means those employees who earn more than 4,500, if you don't have a termination clause in the employment agreement, the law states that the notice period has to be reasonable depending on the seniority of the employee. It could be ranged from 1 to 3 months. So for employees who fall under the Employment Act, that means those who earn less than 4,500, both parties, the employer and the employee, are allowed to pay salary in lieu of notice. In other words, you can fire someone before he served his notice period by paying him salary in lieu of the notice. The employee is allowed to do the same thing. However, for non-Employment Act employees, that means those employees who earn more than 4,500, it is important to draft the employment agreement, the termination clause, in such a way that only the employer can pay salary in lieu of notice. Why? Because if you give the employee, the non-Employment Act employee, the right to pay salary in lieu of notice, and he happens to be a senior employee or an important person, and he found a much better paying job, he can simply just pay the salary in lieu of notice and just drop and walk away the next day. And you don't want that. You want him to do a proper handover and to serve his notice period. Make sure everything is smoothly handed over before he leaves. So the termination clause in the employment agreement should first deal with termination during the probation period. Usually during the probation period, the notice period is less than after confirmation. So the second part of the termination clause will provide for the notice period after confirmation of the employee. The third part of the termination clause would usually deal with summary dismissal. What is summary dismissal? Summary dismissal means the company fires the employee without giving any notice because he has done something very, very bad. Examples of bad things that give the company the right to fire the employee without notice would be if the employee commits a serious or persistent breach, or he's guilty of default, misconduct, or neglect in the discharge of his duties, or if he's found to be dishonest, drunk, or persistent gross misconduct. Okay, he's always naughty, always insubordinate. Another example would be the employee becomes bankrupt or becomes mentally unsound, in other words, mad, or he's charged or convicted of a criminal offense. It is also common to provide that an employee can be summarily dismissed if he is guilty of any conduct that will bring the company in disrepute, which means damages the reputation of the company. For example, if he posts something on Facebook or social media about the company which is negative, okay, or he says, or he doesn't post something about the company, but he posts something about himself, but then he can be identified somewhere in the post that he works for this company. It will damage the reputation of the company. Another common matter that warrants summary dismissal is it is discovered that any information provided to the company before the start of the employment turns out to be false. For example, the educational qualifications turn out to be fake, or he represented the company. He told the company that he has a specific skill. He knows how to use Microsoft PowerPoint. He is good at a certain engineering skill. It turns out that he is incompetent. He's not familiar with it. He lied because he just wanted to get a job. So thanks for watching this video on termination clauses in employment agreement.